Okay, so now we are pleased to have a presentation that was presented by Marion Fremont-Smith, who was introduced earlier. She wasn't able to travel to Salt Lake City, but she kindly has agreed to, pre-tape something for us, and also live available for questions and answers. So here we go.
It is an honor to have been asked to participate in this conference. I am a great admirer of Professor McLaughlin and all the work she's doing in our field of charitable law. And I'm very happy to give you a few remarks today about the history of charitable organizations, including the trusts and corporations that are devoted to conservation purposes, and especially the land trusts. All of these organizations are part of the larger law of charity, which was developed, as best we know, in, believe it or not, the 1300s. So I'm really going to give you a little history. And this was in England at a time when the general law was developing in such a way as to permit individuals and later corporations to hold legal title to property, but be under legal duties to hold that property for the benefit of others, who were called beneficiaries. And these individuals became responsible for holding this property and separating, therefore, the title to property from what we call the beneficial interest. These new institutions were called trusts, thinking about the meaning of the word trust, which was the same then as it is now. At the same time, the courts in England were developing in a certain way that gave them powers to do more than just administer fines or put people in jail. And these were called equity powers, and they were available to the courts to make sure that particularly trustees were carrying out their duties. The suits could be brought by the beneficiaries, and there was a law developed that described the duties of these fiduciaries. To set up a trust, all you needed was property, a person to be the trustee, and beneficiaries who were there and given legal rights to assure that the trustees were carrying out the terms of the trust and following their duties. This was a good development, people felt, but they also wanted to go further because, partly under the influence of the church, partly just because of the way they wanted to help others, the poor, the sick, needy, to support religion and education and other purposes. And it is from that we developed the law of charitable trusts and corporations. And these trusts differed in three major ways from private trusts. One is that their purposes had to fall within a certain category of purposes that were defined by the courts as of general benefit to the community, and I'll talk about that in a minute. There had to be indefinite beneficiaries. If you were going to help society, then you couldn't have any one set of individuals who were going to be the persons who were the beneficiaries. So a class of beneficiaries could be students at a school, patients in a hospital, but it couldn't be the family of X, and that still holds in law today. Because there were indefinite beneficiaries, the law found that there was a hole, because in private trust you could have the private individuals who were the beneficiaries who were going to make sure that the trustees behaved or would take them to court. The answer to this was to appoint the Attorney General in his role as, and it comes to us, parens patriae, in the role of the government as, and the king at the time, as the parent of the country. And so that the Attorney General was given the power to make sure that charitable trustees were carrying out their duties and carrying out the purposes of the trust. The third difference in the way that a charitable trust differed and differs from a private trust is that the courts recognized that these trusts were going to have a special benefit, and that was that they could have perpetual life. Private trusts were subject to something called the rule against perpetuities, and they could only last a certain time. Charitable trusts were, by definition, able to last in perpetuity, and therefore it was recognized, in accordance with that concept, that there would be changed times, and that a purpose that was valid in 1500 or 1600 was not necessarily going to be workable in 2000. And therefore, two doctrines were developed. One was called the Doctrine of Deviation, and under that, if the administration of the trust was no longer feasible, it became impracticable or impossible, the courts could order a change in the method of administration to make it suitable for then contemporary times. The other one that I'm sure many of you know well is the doctrine of Cypre, and that doctrine was dealt with the purposes of the trust. Deviation was for the way you carried it out. Cypre was for the purposes. And if those purposes, charitable purposes, could no longer be carried out in a sensible way, then the courts were authorized to order a change in the documents to make the trust in the early days, the provisions as near as possible to those that the original donor had specified. We have come to consider that a tremendously important part of our contemporary doctrine of charitable and law of charitable organizations, and we have, however, loosened the grounds on which Cypre can be applied and the manner in which it has should be applied. The benefits, as I said, to charitable trusts that were not available to other trusts were that they could last in perpetuity, that income could be accumulated for a reasonable period, and they were not subject to taxation. That may sound familiar. Now, I'm going to fast forward from about 1400 and 1500 to what some would consider the codification of the law of charity, which came about in the Statute of Elizabeth of 1601. And in the preamble to that statute was a description of the kinds of trusts that were to be protected under this statute. And I'm going to just give a little bit of that because it has some language that is pertinent. Some for relief of aged, impotent, and poor people, some for maintenance of sick and maimed soldiers and mariners, schools of learning, free schools, and scholars in universities, some for repair of bridges, ports, havens, causeways, churches, sea banks, and highways. I thought of that when I was listening to the State of the Union address the other night when the president talked about the need to repair our bridges and roads. So again, we are pertinent in 1601. The basic purpose of this statute was to appoint commissions to assure that the charities were behaving and that they weren't being used for personal gain. There was evidently evidence of this, and the statute created commissions that were designed to investigate and bring to court charity trustees who were not carrying out their duties. It was the Attorney General who would bring the legal actions, but the commissions were the individuals who carried out the investigations. This pattern still holds in England today, with one major difference. But until 2006, the purposes of charity were grouped under four what they called heads: poverty, relief of poverty, education, religion, health, and other purposes of benefit to the community. And the Charity Commission eventually developed as a single body that has the power to define whether a charity qualifies for that status under English law. And then the charities are required to file annual reports with them. This is unlike our system, where it is the Internal Revenue Service that really governs the definition of which organizations are charitable, or if you want to call them that, Section 501c3 organizations. Just one quick finish in England, there was unrest as to definitions of charity, and in the newest statute that was preceded by a parliamentary committee and a great deal of thought and input from the public, there are now 13 heads of charity instead of the 4, and one of these is protection of the environment. In the United States, our charity law came with the common law that was adopted in each of the colonies at the time that they landed here, the people landed here, and were adopted when we adopted the Constitution. There was one glitch in that. New York State decided that it would not be in accordance with the revolutionary spirit to adopt the statutes that were in effect in England. And therefore, they, in effect, held that charitable trusts were not legal. What that meant was the development of charitable corporations in New York State and in many of the other states that as they joined the United States, they followed the laws of New York as their model. This meant that charities to be established in New York were established as charitable corporations, but the law allowed, in effect, what would have been a charitable trust by saying that if you gave a restricted gift to a charity, hold X piece of land, or I want the gift to go to the Harvard Kennedy School, then that would be recognized. And it wasn't until the end of the 19th century that a major gift fell because it was held to be a trust in New York. And at that point, the New York legislature adopted a bill approving the use of trusts. But the concept of corporations really took hold in the United States, I think as much because the business corporations were the usual form for doing business, and why shouldn't we have our charity follow the same kind of a format with directors whom we call trustees. But other than that, the powers that we recognize as charitable today follow those from those original English heads of charity: poverty, education, religion, health, governmental or municipal, or other purposes that are beneficial to the community. And that is the way charitable purposes are listed in the Restatement of Trusts and in the new Principles of the Law of Charitable Organizations that we are working on, some of us, for the American Law Institute. Most of the rules that cover charitable trusts also apply to charitable corporations, and that is particularly true for the doctrines of Cypre and deviation. There is some controversy still hanging over the powers of charitable directors of charitable corporations to change the purposes without being under the restrictions applicable to charitable trusts, where this can only be done with court approval. But in general, the powers that apply and the trust restatement treats restricted gifts that are given to a charitable corporation. As I said, a gift to benefit the Kennedy School, the gift to Harvard to benefit the Kennedy School, or a perpetual conservation easement. They are treated under the law restatement of trusts as trusts, and the restatement is silent as to the other assets that a charitable corporation will hold. The principles of the law of charitable organizations is calling them restricted gifts, which we think is a better way to define them, and hopefully that will come into more popular acceptance. The current version of the doctrine of CPRE is that the trust purposes must have become unlawful, impossible, or impracticable, or to the extent it is or becomes wasteful to apply all of the property to the designated purpose. The trust will not fail. No, that is one of the basic rules from the common law, that if a trustee is not appointed, or if the charity that is named in a will is not in existence, the courts will save the gift. It used to be that you had to show that the donor testator had what was called general charitable intent, but that has been abolished, and so that we are in a much more liberal approach to how we handle those gifts. I believe that the doctrine of merger does not apply to charitable conservation easements. And in other words, an easement is meant to last in perpetuity unless a court, with the participation of the Attorney General, agrees to order a different but close purpose, but always within the charitable sector. If there has to be a sale of this property, then the proceeds will be subject to similar restrictions. And many of you have seen this in the conversion of nonprofit hospitals into for-profit hospitals, where the assets are held in a foundation. And it is important that fair market value is paid by the acquiring for-profit. So we switch now to who is regulating, and I talked about the charity commissioners in England, but here effectively it is the Internal Revenue Service, because as you all are aware, it is getting that recognition or determination that you are described in Section 501c3 of the Internal Revenue Code that matters in terms of how you qualify for income tax exemption, but more important for the deductibility of contributions for income, estate, and gift taxes. The charity's definition that came with the first income tax statute was not till 1913, held that there was this exemption for charitable organizations. And what is interesting is that in 1950, fast forward a little bit, when the regulations were finally adopted that describe charitable purposes, they say that the term charitable is used in its generally accepted legal sense and includes, this sounds familiar, I think, relief of the poor, the distressed, or the underprivileged, advancement of religion, advancement of education or science, erecting or maintaining public buildings, monuments, or works, lessening the burdens of government, lessening neighborhood tensions, eliminating prejudice and discrimination, defending human and civil rights secured by law, and combating community deterioration and juvenile delinquency. This does show its source in the 50s. But the ruling also, the regulation also went on to state that the federal interpretation of charitable purposes would be in their accepted legal sense. However, that the courts looking at the federal tax code would use federal law. In fact, however, almost all the revenue rulings and cases have to look to state law because there isn't that much federal law, and the state laws are the common law that I've been describing. Now, I recognize that 170H has added a further layer of complexity to the laws governing conservation easements, but in a sense, what they really do is add details to these common law concepts that I've been describing. I think today that, and I should say that it was in the 70s that we had a number of very specific revenue rulings that recognized the validity of land trusts as tax-exempt organizations. And also the one way that the federal law differs quite drastically from state law is the restrictions in Section 501c3 defining exempt organizations against participating in any political campaigns or in substantial lobbying. And those are not concepts that came from the common law and therefore the state law, but that is a federal interpretation, or from Congress, that obviously is a very important. I would say that the most important issue today when one thinks about conservation is a basic misunderstanding of what the CPRE doctrine is and how it is designed to meet changed circumstances, but not to reflect what the sad phrase that haunts us, really, of the dead hand. We need to remove that dead hand and that concept from our vocabulary. I'm not sure it's going to happen that quickly, but certainly any current iteration of the law as it stands goes back to our history lesson that the law of charities is subject to change. It is meant to be contemporary, and I think in a way that makes it particularly interesting as a subject of study and activity. And thank you.